On behalf of Faculty of Law, General Sir John Kodalawala Defence University, I warmly welcome all of you to the 15th International Research Conference. We feel honored to have you, Mr. Nigel Hatch, paper presenters, judges, and all distinguished guests and participations here at this session, based on the theme of legal reforms and economical revival. Now, I would like to give a brief introduction about Mr. Nigel Hatch, the Honorable Chairperson of the current session. Mr. Nigel Hatch is currently practicing as a President Counsel, specializing in areas of business law, corporate law, labor and employment law, and personal injury law. He holds an LLB from University of Colombo and is a widely published author in the areas of labor law and constitution law. He was the legal advisor to the President of Republic in 2003-2004. Member of the delegation to India on defense matters 2004-2005 and alternate delegate to the UN in 2005. He served as a member of National Education Commission, Securities and Exchange Commission, Company Law Advisory Commission, Sri Lanka Institute of Development and Administration, Council of University of Colombo, the Board of Governors of University of Vocational Technology, the Board of Management of National Institute of Business Management, and the advisory board appointed by President Sirisena after the Easter Sunday bombing in April 2019. He was the acting principal of Sri Lanka Law College. Currently, he serves a member of Board of Management of the Center of the Study Human Rights of University Colombo and a visiting lecturer at University Moratuwa and University of Colombo. Now, I would like to cordially invite the Honorable Chairperson to begin the session. Thank you.
Members, ladies and gentlemen, members who are of the panel opposite me who are due to present papers, students, members of the faculty of the Faculty of Law of the KDU, ladies and gentlemen. I'm chairing a session which has very topical relevance in the current context in Sri Lanka, and it is under the title Legal Reforms and Economic Revival. I believe that 4 papers are due to be presented today, and rather than make any preliminary remarks on the 4 papers, I would like to listen to the presenters because I have the abstracts and have been through them, and I certainly have made some notes about perhaps certain additions which may be required once I listen to them. So I would start this session by, it goes on this order, is it? Yes. Right. Calling upon, it's Ms. Vincy, is it? Ms. Yeah, Ms. Vincy and K Sivanesan to present their paper entitled Applicability of Ordinary Law of Sri Lanka in Foreign Direct Investment, a critical study of the Port City project in Sri Lanka.
Ordinary Law of Sri Lanka in Foreign Direct Investment, a critical study of Port City project in Sri Lanka. The outline of my presentation. Sorry for the interruption. The outline of my research would be the introduction and the methodologies I used for this research, and the discussion part have divided into three main categories.
Oh, I see. Only 10 minutes.
The one is investment policies, and identified Colombo Port City project issues with related to the ordinary law of Sri Lanka, identified Colombo Port City issues with related to the concept of public transparency and public accountability, and the constitutional framework of Colombo Port City project in Sri Lanka and related issues. At last, the recommendation and the conclusion. Colombo Port City project, which was long due in Sri Lankan development agenda, aimed to expand the Colombo Central Business District by reclaiming the sea near Colombo Port and building an ultra-modern city on reclaimed land. However, this project became a reality only with the Sri Lankan government's accepts the proposal from the China Communication and Construction Company. In this project, the total area of 233 hectares of land as a direct investment. This was initiated by the war-winning President Rajapaksa's administration, which prioritized improving economic infrastructure of revive Sri Lanka's position as the center or the pearl of ancient Silk Road, efficiently using the country's strategic geographical location in the Indian Ocean. However, this project has been controversial from its inception due to several reasons. First, it gave rise to apprehension about endangering Sri Lanka's territorial sovereignty and national security due to the concern Chinese investors acquiring land from this landfill on for freehold basis. Secondly, it was alleged that the reclamation work commenced with conducting sufficient environmental impact assessment and in violation of Sri Lankan environmental law. The concern resulted in a massive public outcry against this project. Also, this project was suspended in 2025 in order to address these allegations. Accordingly, Chinese investor and the Sri Lankan government agreed to replace the initial agreement with a new one, providing the Chinese investors only with the leasehold rights for the 116 hectares of markable land for the landfill. In addition, during the suspension of the time, the supplementary environmental impact assessment was conducted to ensure the projects, and it was completed in 2019. In 2021, Sri Lanka established a special economic zone in this landfill administrated by a body corporate known as Colombo Port City Economic Commission. Currently, this project in its second stage of constructing a modern city on reclaimed land, including business and housing district. In this research critically evaluates how the Colombo Port City Act worked under the ordinary law and whether such foreign direct investments decision with related to Colombo Port City project operates in accordance with the concept of transparency and public accountability or not. For this research, I used the preliminary source of information for this research was scholarly texts, journal articles, conference papers, and legislation. And this legal research utilized open domain data for the analysis. The study also makes reference to the current Sri Lankan constitution, administrative directives, and national policies particularly Foreign Exchange Act 2017 and the Board of Investment Law Act 1978 and the Strategic Development Project Act 2018, and with special reference to the Colombo Port City Act, which was controversially passed in May 2021. When moving on to the first discussion, investment policies and identified Colombo Port City project issues with related to the ordinary law of Sri Lanka. In Sri Lankan context, Sri Lanka has implemented an investment policy that is generally hospitable towards foreign investment since the liberalization of the country's economy in 1978. In accordance with the Exchange Act 2017, foreign investment shall not be allowed money lending, pawnbroking, retail trade capital of less than $1 million and coastal fishing. It is further stated by the relevant laws that business activities in which limited investment is allowed or restricted due to the fact of promoting local industries or security related issues. Moreover, the Board of Investment Law of 1978 indicates that the projects are eligible for exemption from certain laws based on the eligibility incentive criteria, such as the minimum level of capital and employment that will be generated by such projects. Under the Strategic Development Project Act 2008, investment projects which are identified as a strategic development project can be granted exemption from laws specified in the schedule of the Act. In addition to these two national laws, the Board of Investment has the sole authority to identify projects eligible for exemption. In Colombo Port City Economic Commission Act, which was controversially came into effect in May 2021, excludes the application of several laws within the area of territory of the port city. The law which has been listed in the Schedule 3 of the Act does not have any application within the area of authority due to the fact of the subject regulated by those laws have been incorporated into the Port City Act itself. Moreover, the companies which are engaged in offshore banking in business shall be registered as offshore companies, and such companies' general administration activities are exempted from the application of provision of the Companies Act of Sri Lanka. It shows that the Port City Act has reduced burden of compliance and controversially impact on the ordinary law of Sri Lanka. Significantly, Schedule 2 of the Port City Act includes the Casino Business Act and Termination of Employment of Workmen Act. It should be noted that these laws are from which foreign investment project can be exempted. Including these laws were controversial and are not included in the Board of Investment Act and Sustainable Development Project Act. Moving on to the next discussion, it's on identified Colombo Port City project issues with related to the concept of public transparency and accountability. Firstly, the Board of Investment can approve projects under Section 16 and 17 of the Act, but the Foreign Exchange Act prevents the Board of Investment from approving foreign investment in non-permitted sector such as coastal fishing or money lending. Similarly, it cannot approve foreign investment in sectors governed by specific laws such as manufacturing arms and military hardwares. Secondly, the Port City Commission has been established, but the Act establishing it does not provide any specific criteria for evaluating application for the investment in the Port City Special Economic Zone. The Section 30 of the Act only stipulates that the Commission is responsible for deciding whether to accept or reject the application for good reasons. Moving on to the third discussion, the constitutional framework of Colombo Port City project in Sri Lankan related issues. The 1978 Constitution of Sri Lanka does not offer a framework for evaluating investment. However, Sri Lanka bilateral investment treaties have the legal foundation according to the Article 157 of the Constitution. The purpose of bilateral investment treaties is to safeguard investor and their international capital investment. Also, parliamentary approval will directly incorporate provision of Sri Lankan investment treaties into Sri Lankan law to translate an investment treaty into domestic law. No enabling legislation is required. For the foreign investor, do not, however, have a right to challenge government or administrative actions that go against the term of this agreement under Article 157 of the Constitution. Moving to the recommendation and the conclusions. Since this Port City Economic Commission Act has controversially passed in 2021 May with the parliamentary majority, since we have issues with related to the provision which stated in the Act, rather than go for a parliamentary process, some scholars also already mention in their articles, and that should be noted, that public transparency and accountability should be there. So to safeguard the sovereignty of the people, referendum would be the best option to pass that. Thank you.
Ladies and gentlemen, I omitted to mention that the two presenters of the paper that we just heard, Ms. Vincy and Ms. Sivanesan, I beg your pardon.
Mr.
Oh,
Miss.
Miss, absolutely. The first name was clearly a female name. I didn't mention their author biographies. Ms. Vincy is a final year undergraduate at the Faculty of Law at this university. This was her first experience in research publication, and her special areas of interest, research areas, are contemporary politics, public international law, international investment law, and international relations and diplomacy. Ms. Sivanesan is likewise a final year undergraduate at this faculty, at this university, and was also her first experience, although she did not physically present this paper, where research publication, and she has similar interest to Ms. Vincy. Thank you. The next paper to be presented this afternoon is by UK Wijesuriya, Miss UK Wijesuriya. Yes, Miss UK Wijesuriya, on the title, The Legal Protection of the River Environment Against Sand Mining, a case study in downstream area of the Kalu River. Now, Ms. Wijesuriya is a graduate who has completed her LLB at the General Sir John Kothawala Defence University, Sri Lanka, and her research interests include environmental law, intellectual property law, and criminal law. A great pleasure in calling upon Ms. Wijesuriya to present her paper.
The chairperson, the panel of judges, ladies and gentlemen, good afternoon to all of you. The title of my presentation is The Legal Protection of the River Environment Against Sand Mining, a case study in downstream area of Kalu River. As we all know, mining sand goes way back to the early civilization, where people earned a fair share through selling sand. In the olden days, people used manual methods, but nowadays we can see illegal, excessive, and mechanized sand mining is being done. The main reason for the increased demand in sand is due to the expansion in the construction industry. And this has created an imbalance between the sustainability limbs, where they have given the priority to the economic development while neglecting the social development and environmental protection. The classic examples are Mahawaya and Dadruwa incidents. My research gap is Kalu River environment is another potential area under illicit sand mining, which is not studied in detail as Mahawaya and Dadruwa. The objectives are to identify the environmental, social, and economic impacts of unregulated sand mining in the study area, and to analyze whether the laws and regulations pertaining to river sand mining are sufficient or not, and to propose suggestions to develop the existing legal framework for better protection of riverine environments. The area selected for the study is the downstream area of Kalu River. Accordingly, 2 mining sites were selected. The first one is the Palathat area, which is 2 kilometers upstream from the coastal line, and Thebuan area, which is 13 kilometers upstream from the coastal line. Socio-legal research methodology and black letter research methodology were used in this study. The data collection was done through structured interviews and key informant interviews through telephone conversations. I should mention that data collection was done during COVID pandemic in August 2021. The respondents included inhabitants, sand miners, proprietors, and sand distributors. The key informants included 1 official from the Central Environmental Authority, 2 officials from Geological Survey and Mines Bureau, and 2 other independent researchers who are involved in this aspect. Apart from them, primary sources such as legislation, secondary sources such as journal articles, websites and blogs, and reports and theses were also referred. Firstly, let's look into environmental concerns in the study area. River bank erosion, river bed erosion, and biodiversity loss were the identified economic concerns in the study area. River bank and river bed erosion are the major concerns as per the respondents. With respect to river bank erosion, respondents in Thebuan area are more concerned about this matter because the river banks are higher compared to the Palathat area. And river bed erosion is also another serious threat because it also causes saltwater intrusion in the dry season. Moving on to socioeconomic concerns, land loss, damage to infrastructure, saltwater intrusion, adverse impacts to agriculture industry, adverse impacts to freshwater shrimp farming are the identified socioeconomic concerns in the study area. Land loss and saltwater intrusion are the major concerns. The Kaluthara Bridge is one of the most vulnerable areas of this illicit sand mining because unregulated and illegal sand mining activities are being done with the help of political influences. And this is an instance where the road had been washed out to the river. Saltwater intrusion is a serious threat because the people in the urban areas of the district use pumped water from the river for their drinking purposes, and that may cause problems with regard to poor drinking water quality. Moving on to implementation of laws and extent of control by institutions. These are the existing laws and regulations pertaining to environmental protection as well as river environmental protection. Among these, the Mines and Minerals Act number 33 of 1992 is the main act regarding river sand mining. And this is important because the Geological Survey and Mines Bureau is also established under this act, and its activities are also governed under this act. Apart from these, the judicial decisions on Mahawaya and Dadruwa cases are also important. Apart from those principal enactments, the Environment Committee of Kaluthara District has imposed several other special guidelines regarding especially to cope up with the saltwater intrusion problem in the area. Accordingly, they have prohibited mining up to 2 kilometers from the coastal line, and only artisanal mining is allowed under the Mines and Minerals Act. According to that category, normally the maximum permissible limit is 35 cubes per month. However, this is further restricted to 25 cubes a month only in Kaluthara area because of the saltwater intrusion matter. And for 35 cubes, 5 workers and 2 boats are allowed, but in Kaluthara, 3 workers and 1 boat is allowed. And for 35 cubes, Mondays, Wednesdays and Fridays from 7 a.m. to 4 p.m. mining is allowed, but it was further restricted to Mondays and Wednesdays in Kaluthara district. Cancelling permits who do not renew their license in every 2 years, and one family can own only one mining site, protecting surrounding plants and trees such as planting mangroves, batakeya, bamboo species, kumbuk, and mentioning the permit number and other details at the site and also on the surfaces of the boats, and keeping the site clean are some other special guidelines given by the Environment Committee. The reason for the unregulated mining activities done in Kaluthara area is because of this improper enforcement of laws and regulations. The pressures for such status are political influences and bribery and corruption. This has caused impacts such as illegal mining outside the prescribed times, exceeding the sand mining limit, and also exceeding the number of trips of sand transporting trucks. So, the suggestions, the responses to develop the existing legal framework. Firstly, enactment of a new law to tackle with sand mafias. The Environmental Foundation Limited has conducted a survey on exploring data on vulnerability of rivers with the use of GIS technology. So, if we use that available data and also explore more about the degree of the vulnerability of rivers, it is suggested to develop a classification and then go for a proper policy measures. Secondly, introducing substitutes for sand to cope up with demand. The substitutes for river sand are sand dunes, granite powder, sand extracted from soil, and washed sea sand. Sand extracted from soil is a very good substitute and it is very affordable, and it was used in constructing the Ramboda Bridge. There's a problem with regard to use washed sea sand because people believe that washed sea sand is not good for building constructions. So if the government make it compulsory to use this washed sea sand in road constructions, it would be a better solution. Thirdly, introducing amendments to the Mines and Minerals Act for proper implementation. The Coast Conservation Department, through the Coast Conservation Act, has given considerable powers to the Director General, and similarly, if the GSMB of the Director General of GSMB also given powers, and also if there is the powers are properly delegated among the respective connected authorities, the political influences can be controlled to a certain extent. And finally, the proper coordination between the Geological Survey and Mines Bureau, the Construction Industry Development Authority, the Road Development Authority, and local authorities, irrigation department, and also the police officials is very much essential to use this scarce sand resource sustainably. So it can be concluded that the existing laws and regulations regarding sand mining are adequate, but the only problem is the proper enforcement is lacking due to many reasons such as bribery and corruption and political influence. So if the government does not take any timely measures to cope up with these current problems, more money will have to be allocated to restore the damaged environment, which could overweigh the cost of prevention. And that cost of prevention will ultimately have to be borne by us, the general public. With this, I conclude my presentation. These are my references. Special thanks to the following who helped me and for their valuable time throughout this study. And thank you for the organizing committee for giving me this opportunity to present my paper at this conference. Thank you.
Thank you, Ms. Wijesuriya. The third paper to be presented this afternoon is by Ms. A.P. Rathnayake on the subject, Mobile Apps Surpassing Doctors, a Legal Standpoint in Light of e-Health. Ms. Wijesuriya is an LLB graduate and a lawyer by profession, and she is, as I'm sure all of you know, a probationary lecturer at the Faculty of Law of this university. I have great pleasure in calling upon Ms. Rathnayake to present her paper.
Thank you, sir. The topic of my presentation is Mobile Apps Surpassing Doctors, a Legal Standpoint in Light of e-Health. When it comes to the introduction of my presentation, I have discussed two main aspects, namely legal issues pertaining to the doctor-patient relationship and the concept of democratization of healthcare and the mobile health technology. What are the legal issues arising from the doctor-patient relationship? You know that doctor-patient relationship is a keystone of care, and the interview between a doctor and a patient has three main functions. The functions are gathering information, developing a therapeutic relationship, and communication of information. The term traditional medical paternalism is an instance where it depicts that the doctor, in a doctor-patient relationship, doctor is in a superior position, he is the sole decision maker, and patient is in an inferior position where he is keeping trust on the decision-making process by the doctor. The medical malpractice litigation is based on the duty of care of doctors, where the duty of care has two main facets, namely duty of care in deciding the treatment and the duty of care in administering the treatment. So whenever the doctor breaches his duty of care, that amounts to medical negligence, where in return he would become liable. What do you mean by the term democratization of healthcare and mobile health technology? Now, this is not a new concept to the world, because democratization of healthcare is a concept which emerged from the information revolution. And medicine at the beginning was considered as a craft, and at present it has been developed to a technological moment and turned into a consumerist model. The mobile technology has affected the doctor-patient relationship in several ways, and nowadays, when it comes to the present context, the delivery of healthcare services is done through mobile and smartphones, and this process is called mHealth. As far as the methodology of my paper is concerned, it is a qualitative approach. The paper has adopted a qualitative approach, and basically I have utilized secondary sources of law as a paramount method of data collection, and the analysis I have used is the content analysis. What are the developments in doctor-patient relationship? Here, I have cited 4 models to illustrate the developments in doctor-patient relationship. The first model is medical paternalism, or this is called Priestley model, where, as I stated earlier, that the doctor is positioned in a superior place and he becomes the sole decision maker, and the patient is comparatively in an inferior position, and he has to trust and he has to keep faith on the decisions made by the doctor. The informative model is bit developed is bit developed when compared to the traditional medical paternalism, where it stands to an instance where the physician is bound to provide all information to the patient, which facilitates the patient to select appropriate medical interventions. And when it comes to the interpretative model, that stands to an instance where the physician acts as a counselor who contributes in the development of the patient's understanding. And when it comes to the last model, it's the deliberate form of doctor-patient relationship, which highlights the role of the physician as a friend or a teacher, where the decision-making is done with the participation of the patient, and the proper communication between the doctor and the patient ultimately decides the fact whether what type of action should be taken or what type of a treatment should be given. Now we come to the stage of information revolution and patience. And there I have stated the main purpose of mobile health applications. You know, we have applications, apps in our mobile phones. The mobile applications basically function to collect data and facilitate, when it comes to mobile health applications relating to medical decision making, these mobile health applications facilitate the patients and users to have the access to information through a software running on the phone. Then a question arises whether there's a conflict between the doctor's duty of care and mobile health technology. So these mobile health applications particularly supportive in the self-diagnosing of a particular disease, and also this is a deviation from the traditional way of meeting a doctor. So there's an exception. So I have discussed two hypothetical scenarios to make this presentation more meaningful. The first hypothetical scenario is about John, who is 40 years old and is living a busy lifestyle, and he often complains about the stress and pressure in his workplace. When he was walking along the street, he got a sudden seizure, and after being hospitalized, he was diagnosed with severe diabetes. John has no time to visit the doctor weekly, and the monitoring of the disease becomes problematic. The option selected by John is to download a mobile health app, which is supportive in the constant monitoring of the disease. So John downloads an app on his smartphone, and the app supports him in the process of monitoring of blood glucose level, and predominantly helpful in educating himself with the methods of exercising and food habits. So this is the first hypothetical scenario I've described to use the mobile health technology and the use of such apps, how the utilization of these apps would become helpful. The second hypothetical scenario is about Jennifer. She's 24 years old, is a girl, lives in a studio nearby her university, and she accidentally got a burnt injury in her hand. The hospital is situated in a distant area, and the injury is not of an extensive and a serious nature. The use of mobile health technology is of high importance to her due to the fact that it facilitates the sending of a photo of the burnt injury to a physician, and who in return notifies about the gravity of the injury. So when you're listening to the hypothetical scenarios that I have explained, sometimes there are problems about the nature of the medical information that would be given through a mobile health app. The first question is, do mobile health apps symbolize DIY medicine? What do you mean by DIY medicine? This is technically known as do it yourself. The use of mobile health apps constitutes an individual venture of the user, which makes the presence of the doctor superfluous in some instances. And also, the danger is that when you are trusting a mobile app and the medical information provided by an app, there's a possibility that leads to the misdiagnosis and the mistreatment of the disease. The second question is, do health apps sabotage informed consent? So when it comes to this, apps involve in the process of collecting data, unlike in other communications, and the consent of the user is obtained in a totally virtual environment. So that consent is taken in an online environment. So you know that the digital information, there's no border. The digital environment is borderless, and when it comes to digital information, the digital information are of vast quantity, and when which information are visible on a screen, on a smartphone, and not on a paper, there's a doubt as to whether the user is capable of comprehending the content or the digital information appeared on the screen. And also, merely a click on the button does not show that the user had given the informed consent, because we don't know whether the patient has understood the relevant aspects or the contents. Mobile apps versus doctors, you know that the traditional relationship between a doctor and a patient is of a collaborative effect. It has a collaborative effect, and also there's a mutual alliance between the doctor and a patient. And also, when a doctor examines a patient, that functions, there are many functions when examining. That means the doctor is a very capable person of collecting symptoms, diagnosis, evaluation, and the management of treatment plans. The mobile health technology has estranged doctors, and that creates doubts relating to the medical malpractice litigation. The use of mobile health apps will cause serious threats to the privacy and the informed consent of the patients. So when it comes to the conclusion, I have identified that mobile health technology, with the emergence of new technologies and internet, mobile health technology has become a popular medium of research for medical patients to find new medical information. And also, they are capable of monitoring their health with the support of mobile health applications in smartphones. But when it comes to the mobile health technology, if you are keeping trust on mobile health technology, that it enables the patients to make own medical decisions, and the technology will mislead the patient about the actual health condition. And also that would influence the doctor-patient relationship in a negative way. And also there would be an uncertainty relating to the liability which can be imposed on a doctor in the event of a breach of his medical duty of care. Thank you.
Honorable Chair, ladies and gentlemen, the present paper is titled as Excessive Debt Burdens of Developing Countries, with special reference to Doctrine of Odious Debts and the cases of political transitions. Such expressions of debts, developing states are some familiar terms that we get to hear in a daily basis. So at this backdrop, let me first give you an outline on my presentation. This is not just a research I engaged in with my academic knowledge, but also an attempt to discover something I was curious and desperately concerned on. Thus, I firstly discuss on the motivation to the present paper and the background link therewith. And then, It briefly points out the research problem, objectives, and the research methodology. Accordingly, I confer the key findings that I derived from the analysis. At the end, some concluding remarks are presented with major recommendations. With those being said, let me now move on to the motivation to the present paper. As we all know, debts are indeed influential in economic recovery of developing countries. However, it's quite problematic as to what extent those are really beneficial to the same. So at this juncture, the bona fide intentions of the creditor state and the commitments of debtor states in sustainable debt management appear to be fundamental and decisive. Therefore, it's safe to say that the debts are only influential if they are not being misused or mismanaged against the interests of citizens. But what if a democratically appointed regime utilizes debts they acquired by their legitimate power for illegitimate purposes? And what if a democratically appointed such a regime, and what if it is burdened up to the citizens to repay such an excessive amount of debts even when they have not been benefited from them? So that desperate feeling you sense directed me to research whether there is a sufficient legal basis to do a justice to your consciousness. Moving to the background of the present research, it is the doctrine of odious debts that grabs the central attention in the discussion. This notion is evolving in its nature and assembles a particular set of equitable consideration to justify an adjustment or a reduction of debt obligations where debts are incurred by a previous regime did not benefit or was used to repress the people. However, the effective enforceability of the said doctrine is mainly based on its international legal recognition and legal parameters, which are somewhat contested and uncertain. Such ambiguities are clearly visible in the context of regime debts, where its application in state transitions are distinctly acknowledged from the instances of government transitions. So given the said background, the present paper mainly addresses the question, does the doctrine of odious debts possess an inherent legal recognition in international law that is competent of addressing the contentious debt obligations aroused in a government transition? By addressing the said legal issue, this paper intends to ascertain the legal extents of the notion and to evaluate the legal instruments that essentially acknowledge its legal existence. And it also aims to comparatively analyze its application in the context of state succession and government succession, and accordingly to identify the developments and deficits in contemporary application of the notion. Eventually, it is expected to propose several pragmatic measures that are competent in overcoming its general deficits. The method adopted to fulfill the present research is the qualitative methodology based on doctrinal analysis. Thus, it is analyzed various legal instruments that are supportive in substantiating an inherent legal recognition. Whilst affirming Article 38(1) of the ICJ statute as the most authoritative instrument which stipulates the major kinds of international legal sources, international conventions, judicial decisions, and other complementary sources are incorporated by referring various primary and secondary resources. So within the said context, now I am moving to the discussion that specifies the key findings of my research. A debt to be considered as odious and consequently to be entitled to have a concession on that account requires to satisfy some major criteria. A.N. Sack, who has presented the first comprehensive articulation of this notion, proposes two major requisites in this regard. Accordingly, debts should be utilized against the interest of the population, and the creditor should have been aware on the same. The Canadian study proposes an additional criterion, the absence of consent of the population. Also, certain normative underpinnings have strengthened the legal basis of this notion, while new classes of debts are also embraced in the modern approach. Let's now move on to the legal instruments that attribute a legal validity to the present doctrine. When considering the most authoritative sort of international legal instruments, the treaties, there are a less number of treaties that explicitly acknowledge odious debts. Namely, the Vienna Conventions of 1978 and 1983 incorporate this doctrine by upholding the clean state rule. It is worth pointing that the International Law Commission has attempted to insert a definition on odious debts to the 1983 Convention, which was subsequently failed. However, Jeff King sensibly argues that the said non-inclusion holds dual significance. On the one hand, it shows some juridical acceptance of the prominence of the doctrine, and at the same time, there's a reluctance to insert the doctrine explicitly. So as of my view, that non-inclusion allows the doctrine to evolve itself by interpreting contemporary demands. A sufficient basis to substantiate the existence of customary international law has not been constituted to this point, and however, the continuous evolution of the doctrine leaves a room for future modifications. And when it comes to the general principles of international law concerning the odious debts, clean state rule and other equitable principles of unjust enrichment, abuse of rights, and good faith are providing a justification on the non-performance of debt obligations in the prescribed manner. Doctrine of unclean hands, which necessitates that he who seeks equity must come with clean hands, and equitable limitations to contractual obligations appear to be vital in this respect. So the major contending principle to the said stance is the notion of pacta sunt servanda, that implies state obligation to respect international agreements entered by their end. Even so, the reassessment of this strict principle under the 1969 Vienna Convention on the Law of Treaties denotes the idea that the said notion is not conclusive and could be surpassed on certain equitable grounds. Judicial pronouncements are also instructive in this respect, and although international tribunals are being reluctant to acknowledge the doctrine explicitly, there cannot be seen a direct refusal on the same. These first three cases exemplify the said fact where the doctrine has been subjected to debate but do not leave a conclusive stance, since some of them are dismissed on the technical grounds or some remarks exist as an obiter dicta of the case. Some progressive implications are shown in World Duty Free case and Tinoco arbitration, and both cases, the debts were utilized for personal enrichment, and thus close judicial attention was drawn to the fact that such debts are illegitimate. Among this traditional context, the scope of regime debts addresses the cases of political transitions, where the successive regime is burdened up to repay an excessive amount of debts whilst the debts so incurred has been utilized against the interest of people. This notion applies. However, the mode of such a political transition is somewhat limited. In its predominant classical context, this doctrine applies only to the cases of state succession on the basis that transformation of international legal personality justified such case. This proposition is now being challenged by various international jurists and legal scholars, where they suggest that such a distinction is not fatal. Even in the Tinoco arbitration, the close judicial attention was drawn to the illegitimate government purpose, regardless of the legitimate de facto government nature of the successive regime. So in this context, illegitimate debts have acquired recognition as a distinct class of debts that is of odious in its nature. The Norwegian government has attempted to survey its legal dimensions, and according to the said approach, various forms of non-justifiable debts seem to be applicable. So given the said remarks, the non-existence of a uniformly accepted ideological and legal beliefs on the doctrine of odious debts can be considered as the major hindrance to its liberal growth. But it also can be argued that such conflicting yet comprehensive propositions lead the path to reshape the doctrine as a well-established rule. When closely observing the application of the doctrine within the said backdrop, it is on the one hand an equitable consideration on the undue debt obligations of citizens in developing countries. But on the other hand, it's of course an inducement to evade debt obligations of countries which can be negatively affected to friendly relations of the states. So to have a fair balance between these two extremes, neither a complete exemption from the obligation nor a total imposition of the burdens would do a justice. Thus, both the creditor state and the debtor state should have been subjected to some initial obligations. As we observed, the creditor should have the awareness on the debt management, but without imposing an initial standard to draw due diligence on the offered debt, this criteria would not be meaningfully executed, and even the chances to reasonably foresee the circumstances shall be assessed, so that the loss which ought to be borne by the creditor can be justified on the ground that he who seeks equity should come with clean hands. So accordingly, it is apparent that the doctrine of odious debts has not been attributed a direct and an inherent enforceability in international legal arena at this point of time. Also, a definite and uniform legal pronouncements on regime debts cannot be observed, and nevertheless, the acknowledgement of the doctrine in international treaty attempts and judicial decisions is instructive, since they undoubtedly admit its existence as a legal doctrine. Therefore, it is suggested to expand its legal dimensions towards providing an equitable rationale to the states, particularly the developing states that have been affected by undue utilization of debts. As previously discussed, it is also proposed that the incorporation of standards which impose a duty on creditor to act with due diligence and making the alleged regimes personally liable for the debts would lead to a fair balance of conflicting interests. Therefore, after a substantial journey through the notion of odious debts, now it's time to bid farewell to this scholarly audience. I hope that I did justice for the theme of my research, and thank you so much. Have a wonderful evening.
Can this be a little louder? Members of the faculty, the ladies who presented their papers, students, ladies and gentlemen. We have now come to the end of this particular session, which at the outset I said was of very topical importance in today's context in the country. Legal reforms and economic revival. At this point in the agenda, there is a portion of time allocated for questions and answers, questions to the panelists and their answers or responses to those questions. So I would open up the floor of the House to anybody in the auditorium who wishes to clarify any particular aspect of any of the four papers that were presented. But I hasten to add that there is a limited time for this, because I too want to make some comments. So I'm using my prerogative as chairman to perhaps take some of that time. But please feel free to ask any questions.
Hi. I just have a small concern regarding to Ms. Ayodhya's presentation. Why is there a failing between the doctor and the patient?
Could you please repeat the question?
Why is there a failure between the relationship of the doctor and the patient in the mobile app?
No, in my research, I'm going to signify the fact that there's no failure between the doctor and the patient relationship. But when it comes to the intervention, I mean the interference of the mobile health technology, sometimes the duty of care owed by a doctor to a patient would be affected or influenced in a negative way. I never say that there's a failure, but the duty of care, duty of care is the base, is the foundation of the liability that we can, a liability which can be imposed on a physician on his negligence. So when it comes to a mobile health app, the use of a mobile health app, the interference or the medical information given out by the specific app would negatively affect the doctor-patient relationship.
I have a small query. If I may, I have two questions. I would direct my first question to Ms. Vincy about her research on the Colombo Port City project. My question is, Ms. Vincy, now you said the act has been passed already and you had recommended to use or utilize a referendum. How do you suggest we set about it? Not necessarily to alter the law. How do you set about it in terms of the referendum and changing the law?
Yes, well, the act is already passed, so now we cannot do anything according to the law. But international investment is something important to a developing country like Sri Lanka. So in future, if we implement any international foreign direct investment such as like Colombo Port City, where we can use natural resources like the country's assets. So in that sense, sovereignty is it's in the people according to the constitution. So rather than going for a parliamentary decision for the incorporation or the implementation of such projects, in the future when we have any kind of foreign direct investment, so we can go for a referendum. Even in the if there are any constitution reforms made in the future, so that we can easily incorporate such laws.
So that will only be applicable to future?
Yeah, in the
emerging
future,
laws.
yes.
All right, thank you very much. I have one more question for Ms. Rathnayake. So in your study, Ms., you've suggested imposing a liability scheme. So whom should we hold liable? Would it be the service provider of that application or whoever who's operating from the other end?
Yes, the service providers, obviously. The applications and the people who would infuse data and information to the applications.
So if it were provided by a particular hospital,
Yes, sometimes be the hospitals, but sometimes with the development of technology, there are fake entering of data as well. So the liability can be imposed in that way.
thank you very much.
Are there any more queries or clarifications?
Yes, so primarily my set of questions will be on behalf of Ms. Vincy. So these days has been discussing about all the investment projects, like as we've been talking about the port city, and in other hands we've been talking about the foreign direct investments in the process. So I've been having the question to be asked, as we call about the sovereignty, and when you look into the constitution, under Article 3 and 4, we have stabilized that the sovereignty is being vested on behalf of the people or the citizens of this country. But when you look into the Port City Act, and it was section 6 subsection E. It directly proves that a person or the commission itself has the probability or the commissional power to make approaches on lease agreements rather than making direct implications to the Land Reform Commission. So my question is, as we've been talking about depth restructuring, or rather all about developing this economic threshold in the country, how we are going to bridge this finance matter or the investment matter in the contradiction of the governing sovereignty of our citizens. The investment in the left and then the sovereignty in the right. My question will be on that matter. Thank you.
In such a case, investment policies for the country, we should have some investment policies for us. So still we don't, in the constitution we don't have any investment policies separately. So we are giving importance to bilateral investment treaties in terms of investment. So we don't have a special policies for investment. So in the law reforms, we should have more investment policies for our country where we can have financial benefits and all.
Thank you, Val.
Okay.
I see a whole number of lady undergraduates. Aren't there any questions from them? Anybody else for that matter? Do I take it that there are no questions? Right, ladies and gentlemen, this is now my summation on the themes that the 4 papers have addressed this afternoon. To my mind, the 4 papers, 2 of which have elements of international law and domestic law, that is the applicability, the Colombo Port City project analysis, and excessive debts or the whole issue of odious debts, and the other 2 papers of environmental protection and indeed degradation with sand mining in the Kalu River, down to a far more personal but a far more important, perhaps a more important aspect, and that is of the mobile apps surpassing doctors and a legal standpoint in e-health. I think these issues, particularly the 2 which have an international law dimension, the Colombo Port City project and the excessive or odious debt doctrine, raise the issues of 2 competing issues which any developing country like Sri Lanka has to address. One is economic development, and the other is what is the legal framework within which that economic development is to be sustained and carried out. Now, I was just told by my colleague at the table that there is no interdisciplinary approach in this faculty at the KDU. Having been a product of the Faculty of Law at the University of Colombo quite a while back, I have been suggesting to them that they too must at least allow law graduates to take one subject from the Faculty of Arts perhaps, economics or political science. And I would assume that what I'm about to say may not be known to the vast majority of the students sitting here today. Now, economic revival presupposes a tremendous debt burden which this country is presently facing. How did we get here? At independence in 1948, when the British handed over independence to this country, Ceylon as we were called then, we had foreign exchange reserves which were more than sufficient. We were the envy of Asia. Singapore got independence almost 12 years later under Lee Kuan Yew in 1965. South Korea's per capita GDP was nothing compared to ours. But what happened? The welfare state and successive governments since independence, which was accelerated in the 1950s and 1960s, imposed a tremendous burden on the national exchequer. The welfare state, where subsidies in health, education and welfare were just handed out government by government in those 20 years post-independence. In fact, they continued even under Mrs. Bandaranaike's government in 1970. That coupled with a rapid population growth from the 1950s. I think our population almost doubled within 10 years. So on the one hand, you have rising population. On the other, you have the state expending in terms of welfare measures in health, free education, rice rations or free rice, free sugar. As a young boy, I remember going with my mother to the local cooperative store with a ration book. None of you have ever experienced that, and thank God that you haven't. Right? So the burden on our economy became almost impossible. There was hardly any growth and investment, hardly any foreign direct investment. We relied on tea, rubber and coconut as our primary export earnings until at least 1978. And we had to, our per capita, or rather our recurrent expenditure on feeding our population, clothing our population, educating our population, and looking after our health needs became too difficult to bear. So low economic growth and a high domestic recurrent expenditure without any financial return in that sense. Now, I must say that Sri Lanka has long been lauded by UN agencies for our Human Development Capital Index. I mean, that's fabulous. We have high levels of literacy. We have eradicated polio and malaria. We have, with high level of literacy, we have a huge number of undergraduates, many of whom are underemployed or perhaps sadly unemployed, and many other progressive development indicia. But the sad truth is that we missed the bus in 1968. In 1968, the Association of Southeast Asian Nations, ASEAN, was established. And Sri Lanka was invited to be a founder member. Jayawardena was then the Minister of State, if I recall, but the then Prime Minister, Dudley Senanayake, was not in favor of us joining. Look at that missed opportunity. Any of you who are interested in comparative economics or political economy would know where the ASEAN states today are and where is Sri Lanka. In fact, when President Jayawardena assumed office in 1978, through diplomatic means, he sought to resuscitate that invitation and said, look, can we now join? ASEAN politely said, no, you've missed the bus, it is too late. You all must be aware of the tremendous economic development in those countries and their per capita GDP, which far exceeds and surpasses what we have today. So and when I conflate another 20 years or 25 years up to the present date, we are now short of foreign exchange. We have a preemptive debt default for the first time in our recorded history. Our ministers and the president, regrettably himself, is with a begging bowl all over the world. And we simply have no money to even have basic imports of petroleum, medicines, milk powder, and food. So economic revival then is very, very important. But there was another important aspect to this, and that was what happened in 1977 when the government changed. Mrs. Bandaranaike's pro-left government from 70 to 77 was, as you know, defeated at the polls. And Mr. Jayawardena enacted the second Republican Constitution, which is the 1978 Constitution, which we now have. It has had 20 amendments, but that is a discussion for another day. But what is important with that is the set of economic policy reforms that President Jayawardena introduced. One was the privatization of state enterprises. The other was the setting up of the Greater Colombo Economic Commission, which became the BOI law of 1978. And the other was also the office of the executive president, which was to be directly elected by the people, independent of parliamentary control, except for impeachment, if the president did not comply with his constitutional obligations and requirements. So here was an office directly elected by the people, immune from the vagaries or the changes in Parliament's composition, because Parliament had a separate election, as you know. A new economic policy of an open economy with minimal state interference, the introduction or indeed the welcoming of foreign direct investment, and of course the Greater Colombo Economic Commission law. Now the BOI law, as I think Ms. Vincy adverted to that, was the first major piece of legislation. And then we had the Strategic Development Projects Act of 2008. Those were the two precursors to the Colombo Port City Act of 2020. So Sri Lanka has, since 1978, done away with a statist-controlled economy, sought to encourage foreign direct investment, and that is one of the issues which the two of these papers, at least, have sought to address. Now, I wish to comment briefly on the paper by Ms. Ranaweera on excessive debt burdens and odious debt. Now, as she did explain, that concept is not fully recognized in public international law. It is still a developing concept. And if you wanted a definition of it, it's essentially where the victor, that is where one group which takes over state power invariably through armed means, through forced means, renounces the debts of the previous regime on the basis of moral grounds that it has been used for self-enrichment and not in the public weal. Now, I want to draw your attention to a decision of the Supreme Court of Sri Lanka when the appropriation bill, which you know is the budget, of 2013 was challenged. As you know, since 1972, there is no post-enactment review of legislation. In short, courts cannot strike down acts of Parliament once Parliament passes them. Instead, we have pre-enactment review, where at the bill stage, citizens are given a window of opportunity to challenge the constitutionality of a bill before the Supreme Court. And the Supreme Court can determine whether it can be passed with a simple majority, a two-thirds majority, or a two-thirds majority and a referendum. The court is also empowered to suggest amendments to the bill which will make it constitutional and compliant with the Constitution. Now, something very interesting happened in the Appropriation Bills 2013. It was challenged on the basis that the authorization of raising foreign loans up to a prescribed amount as set out in that bill was unconstitutional, as it did not require prior parliamentary review of the terms and conditions on which the government of the day was seeking to raise those foreign loans. Now, as you know, under Article 76, Parliament has full control over public finance, the raising of taxes, and indeed anything to do with the whole wider gamut of public finance and taxation. Now, the Supreme Court, in a very interesting decision, reiterated that all acts of Parliament must accord with the doctrine of public trust. Now, I'm sure your lecturers have already exposed you, if you have done your administrative law, to the doctrine of public trust, which essentially means that any act of the executive, legislature, or administrative body must be done in the public interest, in the public weal. And one could extrapolate, or one could position that as an extension of the doctrine of the sovereignty of the people. Articles 3 and 4, that the people are sovereign. So in the present constitution, as you know, we have a separation of powers. The concept was reintroduced after it was explicitly abolished in the first Republican Constitution of 1972. What does that mean? A difference between the executive, the legislature, and the judiciary. So the Supreme Court on this bill said that the best interest of the people and the nation's best interests are paramount. And the only and central concern would be the safeguarding of the people's interest in all decisions taken by Parliament in the exercise of its parliamentary powers, including fiscal accountability. Parliamentary oversight over foreign loans are necessary, as they have not just intra-generational but also intergenerational impact, and is contrary to the doctrine of public trust, which assures to the people both a measure of transparency and strong fiscal accountability. The Attorney General who defends these bills, that's part of their legal obligation, argued before the court contrary to the assertions by the petitioners, that the reporting requirements on the Fiscal Management Responsibilities Act No. 3 of 2003 gave sufficient parliamentary control and oversight over the raising of foreign loans, and sought to repel the contention of the petitioners that there wasn't sufficient accountability and oversight when it came to raising of foreign loans, right? But that view was not accepted by the court, and certain clauses of the bill were determined as being unconstitutional. Now, what happened thereafter? Now, as far as I am concerned, this is a salutary, welcome determination on Parliament's responsibilities in the exercise of its constitutionally mandated power to have complete control over public finance, which an important concomitant is obviously the raising of foreign loans. But sadly, this salutary determination was subsequently reviewed and dissented from within a year. President Mahinda Rajapaksa, under whose regime the 2013 bill was successfully impugned, under Article 129 of the Constitution, you all must be knowing what Article 129, that enables the President to refer a matter, a question of public importance, for determination to the Supreme Court. So he referred the question under Article 129 as to whether the Appropriation Bill 2014, which contained a similar clause to the one which was successfully challenged in the 2013 Appropriation Bill, relating to foreign loans, was whether it was constitutional or not. Now, the court had no hesitation in holding that there was absolutely nothing wrong and everything was hunky-dory with that appropriation bill. So then, after having got through with that, the Minister of Finance presents the budget that is again challenged, and the Supreme Court then once again says that no, there's absolutely nothing wrong with this particular clause, which was successfully challenged in the 2013 determination, same court, different judges, right? And cited its decision under Article, or its opinion under Article 129. So in effect, greater parliamentary oversight over foreign loans was very regrettably, regressively done away with in that particular instant. So those of you who are looking at odious debts, and I'll raise the question to you straight away. Our debts are $56 billion, or give or take a few millions. I don't want to put you on the spot, but are any of our foreign loans odious? Using the criteria that you have expounded, I'm asking you the question.
So within the classical definition, it does not. It's us who conveyed them the regimes who utilized the debts in such a way was elected by our mandate, and they were using our legitimate power. So they did it in a legal boundaries, within a legal extent. So I think that's it.
Right. No, I think the parameters which you just espoused are fundamentally sound. And changes through an electoral democratic process. There may have been bad policy decisions. There is certainly rampant corruption and offshore funds by many of the politicians of all sides and hues. But nevertheless, it won't squarely fall within the definition of an odious debt. Although this is an evolving concept, and we don't know. The whole concept might be widened in time to come to incorporate something like this, particularly when there is rampant corruption. In fact, ladies and gentlemen and students, you will now note that the foreign missions, the foreign countries that are coming to assist Sri Lanka in our present hour of need, are saying two things which are of great significance. They stand by to help the people of Sri Lanka. There's no particular affinity to the government of the day. They are sending us money, foodstuffs, medicines, humanitarian assistance for the people of Sri Lanka. And secondly, which is also significant from my point of view, those foreign countries are telling the government and the people of Sri Lanka, that's us, that they are going to ensure that this hard-earned or badly needed foreign exchange, which is coming to us in our terrible hour of debt need, is going to be properly utilized. Is going to be properly utilized. So hopefully there will be some accountability mechanisms where middlemen and corrupt politicians can be made more accountable. But for that, you will need the public service themselves. As you know, permanent secretaries of ministries are the chief financial officers of their ministries. They'll have to step up their game and ensure that, in fact, whether it's domestic funds or foreign funds, that they are utilized in a transparent and rational way and for the objectives which they were initially provided for. The other point that I'd like to make is Ms. Wijesuriya's paper on sand mining or the degradation, the environmental degradation of the Kalu River. Now, I think I congratulate her for that paper. I think it was very salutary because a sound environment is absolutely imperative in the economic development and the well-being of a state. And her central critique that the laws, the applicable legal regime, she did propound a new Minerals Act or a new Sand Mining Act, but her central theme, as I recall, was that the existing legal provisions were adequate, but were not being adequately implemented. Now that has been the bane of Sri Lanka. Whether it's the police who look askance at something that goes on when there should be further crowd control, or the prevention of a riot and a fray, or sand mining, we have had this problem. And let me tell you, I mean, this is not to pat ourselves on the back. This whole aspect of regulation and transparency is not something that is only endemic to Sri Lanka. It's whole of South Asia, and it happens even in the West. Look at what's happened in the United States of America. And the constant arrests and beating of black Americans, Negro black Americans, by invariably white police. Race relations are still as fraught in America as they ever were, despite the Civil Rights Act from the 1960s under President Johnson. So the issue of the proper implementation of the law is a problem that afflicts any democracy. Some democracies do it better, some do it worse. The final point that I'd like to make is on Ms. Rathnayake's paper, the mobile app Surpassing Doctors, a legal standpoint in the light of e-health. Now, as she very correctly pointed out, the duty of care is the linchpin of, indeed, the law of negligence, which is a fundamental aspect in the law of delict or tort, the duty of care. And I assume that many of you have done torts or delicts up to now and would have learnt the famous snail in the bottle, ginger beer bottle, the duty of care. You're smiling. Have you lectured to them on that? Who does delicts? Okay, isn't delicts a part of the law? Yeah, anyway, you all must have learned that. And the first case since 1932 about how a person bought a bottle of ginger beer from a store somewhere in the UK, opened it, and to his or her horror, I can't recall which sex it was, found a snail or a slug in the bottle of ginger beer. And for the first time, they sued not only the shopkeeper that sold the product, but also the manufacturer. And in a landmark decision of the House of Lords in 1932, if memory serves, the liability, the ultimate liability or the ultimate legal responsibility of a manufacturer was established for the first time. Obviously, in the last 60 years, the law has expanded exponentially, and the liability of manufacturers has in fact increased tremendously. But at the same time, as Ms. Rathnayake would appreciate, the duty of care is just the first test. What is the neighborhood principle, or what is the duty of care that is owed by a doctor, or indeed the provider of an app, to the ultimate patient or user of that particular app? Then, of course, you will get the question of causation. Has whatever medical misadventure or malpractice that has taken place, is it directly linked to the duty of care, or indeed the app that you were analyzing in your paper? And then finally, even if there is causation, a linkage, causation means a linkage between the fault or the wrong and the person who causes that. Is there remoteness of damage? So these are all questions which perhaps you may need to explore further in the development of your paper. Right, I think those would be my contribution in the summary. I believe the final part of the agenda I believe there is a panel of appraisers who will be appraising the papers in terms of their merit. And do we call upon them to address us, or what? How do we do this? Then that's later. So what happens next? So you're going to award certificates now, is it? I believe that the next item of the agenda, although it was not reflected on what was given to me, is the awarding of certificates. And I wish to once again congratulate the 4 presenters. And as far as I'm concerned, I wish to thank the Faculty of Law of the Kotalavara Defence Academy for inviting me. This is my first interaction with you, and it has been a great privilege. Thank you very much.
Thank you, sir. I would like to thank all the presenters for sharing us your immense knowledge. We would like to award certificates to all the presenters of the session, and I respectfully invite the Honorable Chair, Mr. Nigel Hatch, to do the honors. I kindly request all the paper presenters to come forward and accept the certificate. H. K. Vincy.